I want you to imagine walking into a courtroom.
Okay.
But it's not the traditional courtroom you're used to visualizing, right?
Yeah.
Imagine the legal assistant handing the judge a brief, the researcher combing through, like, decades of complex case law, and even parts of the case management system scheduling the trials.
Right. The whole administrative back end.
Exactly. But all of these critical functions are being run by artificial intelligence. It sounds like a sci-fi pitch, honestly, but justice systems worldwide are grappling with this exact reality right now.
Which is a massive paradigm shift.
It really is. I mean, how do we trust a machine with something as weighty or, as irreversible as human justice?
Well, it's a profound institutional shift because we are talking about administrative and adjudicatory decisions that directly impact human liberty, property, and, well, fundamental rights.
Yeah, the stakes literally could not be higher.
Right. So when algorithms are introduced into that ecosystem, the standard for trust cannot simply be that the software functions smoothly most of the time. The threshold for reliability, transparency, and accountability, I mean, it has to be virtually absolute.
Okay, let's unpack this. Because today we are doing a deep dive into the actual rule book being drafted for this very scenario.
The literal blueprint for robot justice.
Basically, yeah. We have an incredible stack of source material specifically focusing on a proposed framework. It's called the Draft Guidelines for AI Oversight and Accountability in Courts.
But we aren't just looking at the court's ideal scenario.
Right, we are not just going to read through the rules. We also have this highly critical commentary that places these draft guidelines side by side with another major standard known as the DGPSI AI.
Right, the Data Governance and Protection Standard for India for AI.
Exactly. And our mission in this deep dive is to explore this emerging high-stakes rulebook. We want to understand the mechanics of how a justice system plans to audit, monitor, and potentially, pull the plug on an algorithmic system before it makes a catastrophic error.
Having that comparative commentary is invaluable here. If we only look at the court's proposed guidelines, we'd just see their perfect world. The commentary pulls back the curtain on the logistical nightmares and the technical contradictions.
Yeah, and the very first hurdle is the onboarding process. Because before an AI can even touch a court docket, it needs to be approved. But how do you, interview an algorithm?
Well, you can't exactly ask it for references.
Right.
The draft guidelines mandate that the AI has to pass what is essentially a highly technical bar exam. It's formally called a Technical and Ethical Impact Assessment, or TEIA.
TEI, okay.
Before any system is integrated, the authorities have to map out its purpose, its underlying architecture, and thoroughly evaluate the quality of its training data.
Let me stop you there, though, because I really want to look at the mechanics of that assessment. The guidelines demand that the AI demonstrate explainability.
Which is a huge buzzword right now.
It is. And on the surface, that sounds great. We want the AI to show its work, like a math teacher demanding to see the steps, not just the final answer.
Right.
But under the hood, how is that technically possible? Neural networks are famous for being these impenetrable black boxes. They don't reason through logic trees. They just predict tokens based on billions of parameters.
Yeah, it's statistical probability, not conscious logic.
Exactly. So how can a court mandate explainability from a system that inherently cannot explain its own internal probability matrix?
That is one of the most significant technical hurdles in modern computing, and you are entirely right to flag it. The court is essentially demanding a diagnostic readout of a process that is often opaque even to the developers who built the thing.
Which seems like a paradox.
It is. The assessment is supposed to look for risks of error and hallucination, but mapping the pathway a generative model took to arrive at a legal conclusion is incredibly complex. I mean, it requires specialized tools that try to interpret the weights the model assigned to different inputs.
And that's an evolving science, right? Not a settled one.
Far from settled. And even if a vendor somehow proves their model is relatively transparent, the AI does not just get handed a gavel.
Right, there's the sandbox.
Yes. The framework outlines a probationary period of controlled environment testing. Think of it as an AI sandbox. The rule is that during this testing phase, the AI is completely quarantined.
So it's locked in the basement, essentially.
Figuratively, yes. It cannot touch the primary operational networks, and its outputs cannot be used in any actual adjudicatory decisions. The intention is clear. The court wants to run simulations.
Okay, so they feed it old case files and see what it does.
Exactly. They feed the AI closed case files and historical data to see how it behaves before letting it interact with live, dynamic court processes.
But I have to push back on the premise of this sandbox. I mean, is testing in a vacuum really the same as testing in a high-stakes, real-world courtroom?
It's a very different environment.
Right. And AI might perform perfectly when processing static historical documents where the outcome is already known. But the real world is incredibly messy. People lie on the stand, documents are forged, novel legal arguments are just invented on the fly.
It's chaotic.
So how does succeeding in a sterile simulation prove the tool is actually safe for live deployment?
What's fascinating here is how the critical commentary addresses that exact illusion of safety. Because the court's framework focuses heavily on this deployment stage sandbox.
Right, after it's already built.
Exactly. But the alternate framework, the DGPSI AI, argues that if you wait until the software is in the court's sandbox to figure out if it has critical flaws, you are already way too late.
Oh, wow. So they want to push the responsibility earlier?
Yes. The DGPSI AI demands strict documentation of guardrails, risk modeling, and human handler contact right from the developer's end, long before the court signs the contract.
Which means you're demanding the safety mechanisms be, like, baked into the foundational code, rather than just bolting a metal detector onto the front door of the courthouse.
Precisely. You have to govern the creation of the tool, not just its behavior in a highly controlled artificial environment.
Okay, so let's assume the system passes the sandbox phase and goes live. Now you have a whole new problem. AI does not stay static. It drifts.
Right, model drift is a huge issue.
It adapts, and depending on the new data it ingests, its performance can degrade over time. And the guidelines acknowledge this, right? They require the courts to maintain a master ledger, an AI register tracking every system, and mandating continuous technical and legal audits.
Yes, under Section 38, I believe.
Right. But there is a massive restriction here. The guidelines dictate that these audits must be entirely in-house.
Which is a very controversial choice.
Yeah, under no circumstances can the source code, the algorithms, or the datasets be shared with any third-party or private entity outside the court premises.
Well, the motivation behind that restriction is data sovereignty. Courts process highly sensitive, classified, and personal information.
Sure, you don't want a random tech startup reading sealed court records.
Exactly. The framework prioritizes absolute data security, trying to ensure that proprietary tech auditing firms do not get access to judicial databases.
I understand wanting to protect the data, but the mechanics of this are just baffling to me. We just established that auditing a neural network requires cutting-edge, highly specialized tools.
It does.
It requires adversarial testing or red teaming, where you intentionally try to break the model to find its hidden flaws. You cannot do that with a standard IT checklist.
No, you absolutely cannot.
It's like a local bank deciding to conduct its own cybersecurity penetration testing against nation-state hackers instead of hiring outside experts. The court's internal IT department is suddenly being asked to act as world-class algorithmic auditors.
Which is exactly where the commentary levies its heaviest critique. The DGPSI AI framework specifically recommends external third-party audits for this exact reason.
Because it's too hard to do internally.
Right. Conducting a comprehensive algorithmic audit is a highly specialized, incredibly scarce skill set. It usually falls to a dedicated data protection officer and massive tech organizations.
Yeah, you need engineers who spend their entire lives studying machine learning vulnerabilities. You can't just hand that job to the court administrator who fixes the printers.
Exactly. By locking the audit process down to internal personnel, the courts are creating a really dangerous blind spot. Without external transparency and specialized expertise, an in-house audit might completely miss profound systemic errors.
Like a slow-moving bias or something.
Yes. They might lack the computational resources or the specific forensic knowledge required to identify a subtle bias that is slowly creeping into the system's recommendations.
And what happens when they miss that subtle bias? Because technology inevitably fails. Let's look at the emergency protocols. The guidelines mandate an AI incident database to record malfunctions.
Which is a good step.
It is. But the primary defense mechanism relies entirely on the human beings in the room. The framework explicitly states that the human officer supervising the AI retains full discretion to accept, modify, or reject any AI-generated output.
Right, based on their independent professional judgment. It is the classic human-in-the-loop safeguard.
It's a move-a-loop play.
The system is designed so that the algorithm only advises, while the human retains the ultimate authority to decide.
Let's look at the psychology of that, though. There is a well-documented phenomenon called cognitive offloading.
Or automation bias.
Yes, automation bias. When humans work alongside a highly efficient machine, our brains naturally stop doing the heavy lifting. We blindly follow our GPS into dead-end streets because the screen told us to.
Right, we just trust the glowing rectangle.
Exactly. So if you take an overworked court clerk who has to process, I don't know, 500 documents a day, and the AI has been correct the first 499 times.
Are they really going to scrutinize document number 500?
Exactly. Are they really going to use their independent discretion? No, they are going to rubber stamp it.
Human complacency is arguably the greatest vulnerability in any automated system. The assumption that a human will continuously and rigorously double-check a machine that appears to be functioning perfectly ignores basic human psychology.
Right.
And that one hallucination, their rubber stamp, could derail an entire trial.
Now, the guidelines do include an emergency fallback protocol for when the system demonstrably crashes, allowing the court to transition back to manual processes.
Yes, Section 42 covers that.
But given the speed at which AI operates and the reality of human automation bias, which is talked about, a graceful fallback plan does not seem sufficient for a high-stakes environment.
Which brings us to a pivotal distinction highlighted in the commentary. A fallback protocol essentially means shifting to paper when the software goes offline. But the DGPSI AI framework argues for something much more aggressive when dealing with critical risks.
And what is that?
A literal kill switch.
Oh, wow. Okay, walk us through the technical difference between a fallback plan and a kill switch in a networked environment.
Well, a fallback plan is procedural. The system stops working and the humans change their workflow. A kill switch, on the other hand, is infrastructural.
Meaning it's built into the hardware or the core network?
Right. It assumes the AI might not just stop working, but might actively start doing harm, like rapidly corrupting a database, producing cascading hallucinations, or executing biased automated decisions at a speed humans cannot even track.
So you need a way to stop it immediately.
Yes. A kill switch is a hard-coded, instantly accessible mechanism to sever the AI's API connection. It physically cuts the algorithm off from the court's network, stopping the data flow instantly to contain the bleeding.
That makes total sense.
The commentary argues that for judicial systems, you need the ability to pull the plug instantaneously, not just a polite plan for what to do when the server goes down.
Here's where it gets really interesting, though, because everything we've talked about so far is how the courts manage the AI they own.
Right, internal systems.
But external parties, lawyers, plaintiffs, the public, they're bringing their own AI tools into the courtroom. So how does the justice system handle AI-generated evidence and legal documents brought in from the outside?
This is where the framework pivots from administrative oversight into strict legal liability. The rules mandate absolute transparency.
Okay.
If a lawyer uses an AI tool to prepare pleadings, draft legal arguments, or organize evidence, they are legally required to disclose it using specific certification forms.
The guidelines specifically mention the use of synthetic data.
Yes.
So, for example, if a lawyer uses an AI physics engine to generate a simulation of a car crash to present as evidence, they have to explicitly declare that the data is synthetic.
Exactly.
But the liability clause attached to this is what makes it so fascinating to me. The rule states that if a submitted document or piece of evidence is found to be false, hallucinated, or fabricated by an AI, the person who submitted it bears full responsibility.
The court is preemptively rejecting the defense of algorithmic error.
It's the modern evolution of the dog ate my homework. A lawyer cannot stand before the judge and say, oh, the AI hallucinated that legal citation, it isn't my fault. The court treats the AI's hallucination exactly as if the lawyer had looked the judge in the eye and lied.
Right. You can use the tool for efficiency, but you absorb 100% of the professional risk for its output.
Which is pretty intense.
But it's a necessary boundary. I mean, we have already observed real-world instances where legal professionals use generative AI to draft briefs, and the underlying language models simply invented case law.
Right, fabricating citations, case names, judicial opinions just out of thin air.
Exactly. By establishing strict liability, the framework forces the human operator to manually verify every single claim the AI generates.
But verifying those claims brings up a massive logistical problem. I mean, how does the court actually catch a fabricated citation or a subtly deep-faked piece of audio evidence if the lawyer just fails to disclose it?
That is the million-dollar question.
Because the guidelines propose the creation of an AI content verification authority.
Yeah.
This would be a dedicated institutional body tasked with continuously updating the standards and tools required to verify generative AI content in the judicial process.
The ambition of that proposal is notable, sure. But the critical commentary issues a stark warning about its feasibility.
Because it's basically impossible to keep up.
Establishing an effective AI content verification authority is not simply a matter of buying a software license.
Right, because generative AI is not a static target. The models generating deep fakes and synthetic text are constantly evolving. It's an arms race.
Exactly that. Detection models work by identifying specific artifacts, a strange pixelation pattern in a video or repetitive linguistic structures in text.
But the AI learns from that.
Yes, generative models are often built using adversarial networks. They're literally trained to fool the detectors. To actually verify submitted content at scale, the court system would need to build and maintain a massive world-class digital forensics laboratory.
Huh.
They would need top-tier forensic engineers on standby, constantly updating their detection algorithms.
So you're asking a local courthouse to fund and operate the equivalent of a national intelligence agency's cyber forensics division.
Essentially, yes.
The intention to catch fabricated evidence is obviously vital, but the financial and technical scale required to actually execute it seems completely detached from the reality of current judicial budgets.
Which serves as a perfect transition into the fundamental structural flaw identified across this entire draft framework.
Okay.
We have discussed the sandboxes, the in-house auditing requirements, the kill switches, and these proposed forensic authorities.
Right.
The obvious question is, who is actually going to build, manage, and pay for all of this architecture?
Well, the framework suggests a decentralized approach. It outlines that individual AI secretariats should be established at every single high court.
Yes.
So each individual high court is expected to manage its own AI register, conduct its own complex technical audits, design its own incident databases, and develop its own emergency fallback protocols.
If we connect this to the bigger picture of technology governance, that decentralization is a recipe for technical debt and administrative chaos.
I can imagine.
The commentary argues forcefully that this approach will lead to an unsustainable duplication of effort.
Think about the practical implications of that. You would have dozens of different high courts, all independently trying to figure out how to red team a complex language model.
And arriving at entirely different conclusions.
Exactly. You could have a scenario where a lawyer uses an AI tool in Mumbai, and it's perfectly acceptable, but the exact same tool is banned in Delhi because their local IT department used a totally different methodology for the ethical impact assessment.
It invites conflicting decisions and fragmented standards across what should be a unified justice system.
Yeah, that sounds like a nightmare.
It is. The administrative burden of expecting every local jurisdiction to become an expert in algorithmic governance is so high that the commentary warns many courts will simply ignore the directions altogether.
Because they just don't have the resources.
Exactly. If the rules are too complex to implement locally, the entire objective of regulation fails.
So what is the alternative architectural model then? How do you govern a sprawling technology like this without breaking the local courts?
Well, the commentary suggests the only viable solution is centralization. Instead of every high court struggling in isolation, there needs to be a centralized expert team.
Like a national committee.
Right, perhaps a grand committee composed of leadership from across the jurisdictions. This central body would pool the resources, hire the specialized forensic experts and data protection officers, and just handle the heavy lifting.
That makes a lot of sense.
They would standardize the impact assessments, conduct the complex external audits, and then distribute those standardized tools and protocols down to the individual courts.
That makes far more sense from an engineering perspective, honestly. You govern a centralized algorithmic problem with a unified, centralized standard.
Exactly.
So what does this all mean? We have journeyed through an incredibly complex landscape today. We examined the sheer difficulty of forcing a black box neural network to explain its logic.
Which is still an unsolved problem.
Right. We looked at the tension between securing sensitive court data and the necessity of bringing in outside experts to truly audit an algorithm. We explored the psychological trap of automation bias, the infrastructural necessity of a hard kill switch, and the court's absolute refusal to accept the algorithm made me do it defense.
Which is going to catch a lot of lawyers off guard.
Absolutely.
Mm-hmm.
And it all culminates in the realization that without centralized, standardized oversight, this entire ambitious framework could just collapse under its own weight.
It represents a microcosm of the exact struggle every major institution, both public and private, is facing right now.
Yeah.
How do you integrate the unprecedented efficiency of generative AI without fundamentally compromising the integrity of your decision-making process? The judicial system is attempting to draw the map, but it is a territory full of technical contradictions.
And that is why this matters to you, the listener, even if you never interact with the legal system. The mechanics we just unpacked, how to demand transparency from a system you don't fully understand, how to fight the urge to blindly trust a machine's output, and determining who takes the fall when the algorithm lies.
These aren't just courtroom problems.
Exactly. These are the exact same mechanics applying to how you use AI in your own industry, your own business, and your daily life.
The courts are being forced to write these rules down, but the rest of society is currently operating without them.
Which leaves me with a final thought for you to ponder. We just spent this entire deep dive examining how the judicial system is attempting to build a massive, complex fortress of guardrails.
Sandboxes, audits, kill switches.
Yes, they require impact assessments, quarantine sandboxes, continuous adversarial audits, infrastructural kill switches, and literal forensic verification laboratories just to feel safe utilizing AI.
It's a huge undertaking.
Right. If the courts feel this intense paranoia-level protection is absolutely necessary to protect the truth and prevent catastrophic errors. What does it say about the fact that we are all blindly integrating these exact same AI tools into our personal decisions, our work emails, and our daily lives without a single guardrail in place?
That's a sobering thought.
The next time you open a generative AI to summarize a complex document or ask for critical advice, remember that courtroom. Remember the sandbox, the kill switch, and the strict liability. Because outside the courtroom, there is no AI content verification authority checking the fact. There is only you,